Hello, this is R.J. Deacon reading the Supreme Court of the United States opinion syllabus in CARR versus SAUL, Commissioner of Social Security. If you'd like to support the podcast, or if you'd like to put a little gas in my motorcycle so I can get to my public defender internship, stay tuned to the end of the podcast. Certiorari to United States Court of Appeals for the 10th Circuit. Argued March 3rd, 2021. Decided April 22nd, 2021. Petitioners are 6 individuals whose applications for disability benefits were denied by the Social Security Administration, SSA. They each unsuccessfully challenged their respective adverse benefit determination in a hearing before an SSA administrative law judge, ALJ. The SSA Appeals Council denied discretionary review in each case. Thereafter, this court decided Lucia versus SEC, which held that the appointment of Securities and Exchange Commission ALJs by lower-level staff violated the Constitution's Appointments Clause. Because the SSA ALJs who denied petitioners' claims were also appointed by lower-level staff, petitioners argued in federal court that they were entitled to a fresh administrative review by constitutionally appointed ALJs. In each case, the Court of Appeals held that the petitioners could not obtain judicial review of their Appointments Clause claims because they failed to raise those challenges in their administrative proceedings. The Supreme Court held decision is reversed and remanded, and Justice Sotomayor delivered the opinion of the court. The Courts of Appeal erred in imposing an issue exhaustion requirement on petitioners' Appointments Clause claims. Administrative review schemes commonly require parties to give the agency an opportunity to address an issue before seeking judicial review of that question. Such administrative issue exhaustion requirements are typically creatures of statute or regulation. But where, as here, no statute or regulation imposes an issue exhaustion requirement, courts decide whether to require issue exhaustion based on an analogy to the rule that appellate courts will not consider arguments not raised before trial courts. That's Sims versus Apfel. The desirability of a court imposing a requirement of issue exhaustion depends on the degree to which the analogy to normal adversarial litigation applies in a particular administrative proceeding. In Sims, which declined to imply an issue exhaustion requirement to SSA Appeals Council proceedings, the court explained that the rationale for requiring issue exhaustion is at its greatest when the parties are expected to develop the issues in an adversarial administrative proceeding, but is much weaker when an administrative proceeding is not adversarial. That's same case. Although Sims dealt with administrative review before the SSA Appeals Council, much of the opinion's rationale applies equally to SSA ALJ proceedings. Even assuming that ALJ proceedings are comparatively more adversarial than Appeals Council proceedings, the question remains whether the ALJ proceedings here were adversarial enough to support the analogy to judicial proceedings. That undergirds judicially created issue exhaustion requirements. Sims, and that's quoting the plurality opinion. In the specific context of petitioners' Appointments Clause challenges, 2 considerations tip the scales decidedly against imposing an issue exhaustion requirement. First, agency adjudications are generally ill-suited to address structural constitutional challenges, which usually fall outside the adjudicator's areas of technical expertise. See, for example, Free Enterprise Fund versus Public Company Accounting Oversight Board. Second, this court has consistently recognized a futility exception to exhaustion requirements. See, for example, Bethesda Hospital Association versus Bowen. Both considerations apply fully here. Petitioners assert purely constitutional claims about which SSA ALJs have no special expertise and for which they can provide no relief. United States versus L.A. Tucker Truck Lines. Distinguished. The Commissioner's contention that petitioners cannot obtain new hearings because they did not timely challenge their adjudicator's appointments presumes what the Commissioner has failed to prove, that petitioners' challenges are in fact untimely. The Commissioner's reliance on Ryder v. United States and Lucia is misplaced, and neither decision had occasion to opine on what would constitute a timely objection in an administrative review scheme like the SSA's. The decision below is reversed and remanded. Justice Sotomayor delivered the opinion of the court, in which Chief Justice Roberts and Justices Alito, Kagan, and Kavanaugh joined, in which Justice Thomas, Gorsuch, and Barrett joined as to parts 1 and 2A and 2B2, and in which Justice Breyer joined as to parts 1, 2B1, and 2B2. Justice Thomas filed an opinion concurring in part and concurring in the judgment, in which Justices Gorsuch and Barrett joined. Justice Breyer filed an opinion concurring in part and concurring in the judgment. Thank you for listening. If you'd like to support the podcast, you can find me in the show notes, the PayPal link, or find me on Patreon, or contact me at rhodesscholar80@gmail.com. That's ROADS and the number 80.